The Insolvency and Bankruptcy Code was enacted in 2016, following decades of recommendations suggesting improvements to the previous insolvency regime. Hi friends and professional colleagues, I am Ayushi Jain, partner at APAC Associates LLP. Today I am going to talk about the code that marked a sea change from the previous regime, that is the Insolvency and Bankruptcy Code, referred to as the code in this video. This is the 23rd video of APAC's web series, that is One Concept, One Slide, initiated by APAC Associates LLP. In this video, we would provide a bird's eye view of the code. We would publish specific video on every topic covered in this video like CIRP, bankruptcy, etc. in near future. We look forward to receiving your queries, comments and feedback by any means given on the slide. All of our videos are covering a topic updated as on the date of publication on our YouTube channel. Since MCA has brought some amendments in the provisions related to related party transactions, that is RPT, and incorporation of companies, we have added additional amended slides in the earlier presentations on these topics available on our website. The link to these presentations are also available on the description box of our respective videos on our YouTube channel and can be downloaded therefrom. One of the aims of an insolvency law is to maximize the value of the assets of the corporate debtor. The key aim of the code is to enhance the value, which is usually dependent on the time taken to resolve the insolvency, since it erodes over time. There are concerns that delays may make reorganization impossible and may induce liquidation, causing value destruction. To begin with, we need to understand some basic concepts provided in the code. The first and the foremost is default. It means non-payment of the debt when whole or any part or installment of the amount of debt has become due and payable. It means default arises as soon as any debtor is unable to pay any installment. It is further clarified by famous case law, that is Messrs. Innovative Industries Limited versus ICICI Bank and another. It was held that the adjudicating authority is bound to issue a limited notice to the corporate debtor before admitting a case for ascertainment of existence of default based on the material submitted by the corporate debtor. Second is corporate debtor. Corporate debtor is any person who owes a debt to any person. Third is the operational creditor. It means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Operational debt here means a claim in respect of the provision of goods or services including employment, or a debt in respect of the payment of dues arising under any law for the time being in force and payable to the central government, any state government or any local authority. Fourth is the financial creditor. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. Now, here financial debt here means debt along with the interest, if any, which is disbursed against the consideration for the time value of money and includes money borrowed against the payment of interest, any amount raised under credit facility, any amount raised pursuant to any note purchase facility, or the issue of bonds, notes, debentures, loan stock or any similar instrument. The amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease under the Indian accounting standards or such other accounting standards as may be prescribed. The last one is receivables sold or discounted other than any receivables sold on non-recourse basis. Apart from this, we need to take into consideration who all are governed by the provisions of the IBC or to whom this code applies. The provision of this code shall apply in relation to their insolvency, liquidation, voluntary liquidation or bankruptcy as the case may be, to any company incorporated under the Companies Act 2013 or under any previous company law. Any other company governed by any special act for the time being in force, except insofar as the said provisions are inconsistent with the provisions of such special act. Now the second one is limited liability partnership incorporated under the Limited Liability Partnership Act 2008, personal guarantors to corporate debtors, partnership firms and proprietorship firms, and individuals other than personal guarantors to corporate debtor. And the last category is any other body corporate incorporated under any law for the time being in force, as the central government may by notification specify in this behalf. As of now, the central government has not yet notified any other entity apart from these specified above. Now here for the first three persons, the adjudicating authority shall be the National Company Law Tribunal, that is NCLT, and for the partnership or proprietorship firms or individuals, it would be Debt Recovery Tribunal, that is DRT, having territorial jurisdiction over the place where the registered office of a corporate person or debtor is located. There are two ways under NCLT. First is Corporate Insolvency Resolution Process, that is CIRP. In case of default of minimum 1 lakh rupees, the financial creditor is required to send a demand notice to the corporate debtor prior to the application to NCLT as an additional requirement for initiation of corporate insolvency resolution process. The operational creditor or the corporate debtor itself may directly file an application for initiation of corporate insolvency resolution process, and the demand notice is not applicable, is not mandatory for an operational creditor. Thereafter, if the application is admitted by NCLT, then CIRP begins. During this process, a committee of creditors is formed and a resolution professional is appointed who shall be responsible for smooth and effective flow of this process. This committee of creditors then approves the resolution plan, which may either provide for liquidation or revival of the corporate debtor, and the same needs to be approved by the adjudicating authority. In case a revival plan is made, the committee of creditors and the resolution professional shall act upon accordingly. Otherwise, in case decision with respect to liquidation is made, then a liquidation estate combining all the assets of the corporate debtor would later on be distributed as per the priority waterfall chart according to the claims admitted. The entire process of corporate insolvency shall be completed within 180 days from the date of admission of application unless extension is availed. However, subject to fulfillment of certain conditions, the same process may also be completed within 90 days from the date of admission of application unless extension is availed, and this shall be known as fast track insolvency resolution process. Now, we would come out with specific videos for corporate insolvency resolution process and fast track process. Now, the second way is voluntary liquidation process. Apart from CIRP, the corporate debtor may also undergo the voluntary liquidation process when the corporate debtor voluntarily and without any default undergoes liquidation. For further details on voluntary liquidation, you may refer to our 20th video published on our YouTube channel. In order to proceed further with filing of an application with DRT, the minimum amount of default shall be 1000 rupees. There are two processes. First one is fresh start process. In this process, the partnership firms, proprietor firms or the individuals may file a fresh start application with DRT in order to pay the earlier debt in a refined manner and undergo a fresh start process. For this, a resolution professional is appointed for effective functioning of the entire process, and a discharge order shall be passed by the adjudicating authority, that is DRT, for discharge of the debtor from the qualifying debts. Another scenario is when the debtor himself or the creditor files an application for insolvency resolution process. The said application needs to be submitted by DRT to DRT, followed by appointment of resolution professional. Later on, repayment plan is worked upon for revival of the corporate debtor, which needs to be approved by the DRT and the creditors. In case revival plan is not made or not agreed or not implemented, or any such thing where revival of the corporate debtor is not possible, then DRT shall pass a bankruptcy order. This order shall provide for administration and distribution of the estate of bankrupt. It is always advised to keep in mind the landmark judgments given by authority so as to stay updated with the clarification in law brought by them. You can refer our other videos already published on our YouTube channel. You may also subscribe for our weekly light and monthly light newsletters for all latest updates in areas such as SEBI, FEMA and Companies Act, etc. You can also follow us on Facebook and LinkedIn page for daily updates by referring the details given on the slide and in the description box below. We have tried to cover about the Insolvency and Bankruptcy Code 2016, the important concepts involved therein, the applicability of the code along with the broad steps involved in the corporate insolvency resolution process of a corporate debtor, the fresh start process, and the insolvency resolution process for individuals, partnership firms, and proprietorship firms. We request you to share your views and advice on this web series, including the topics that you want us to cover in coming videos. Thank you.